I'm Beth Ermatinger Hannon, an appellate lawyer at Guess Weber Mullins in Milwaukee. Over the past several years, I've written an annual article, following in the tradition of Dan Hildebrandt, about significant decisions from our state Supreme Court.
My name is Mike Brennan. I'm a trial and appellate attorney at Guess Weber Mullins, also in Milwaukee. For the last 2 years, I've written an article for the Wisconsin Lawyer concerning recent significant Wisconsin federal court decisions. When the United States District Court for the Eastern District of Wisconsin, or the Western District of Wisconsin, or the United States Court of Appeals for the Seventh Circuit issue an opinion which interprets Wisconsin law, sometimes it can have an effect on Wisconsin courts and Wisconsin practitioners. So the purpose of the article was to highlight any significant decisions that were to come down from those courts.
Mike, I know your article touched on 6 or 7 different federal decisions from the past year. Is there any one that really stands out in your mind about which Wisconsin practitioners should be aware?
I think the one that stood out the most was called Gibson versus American Cyanamid. It was a decision by Judge Rudolph Randa of the United States District Court for the Eastern District of Wisconsin. In that decision, Judge Randa addressed a 2005 Wisconsin Supreme Court decision called Thomas versus Mallet. Thomas versus Mallet had made a determination adopting the risk contribution theory of liability with regard to lead paint pigment manufacturers. As a result of Thomas versus Mallet, a number of those cases were filed in Wisconsin. Some of those cases ended up having diversity jurisdiction and were removed to the federal courts. This was one of those cases. In Gibson, that decision, a defendant named Arco had moved for summary judgment utilizing a United States Supreme Court opinion of the name of Apfel. That opinion itself was not a unanimous opinion, rather it was a plurality determination. And that plurality determination was utilized by Judge Randa in his decision.
And was the decision by Judge Randa in conformity with the state Supreme Court's decision in Mallet?
It overruled that decision, indicating that the application of that type of theory of liability would be unconstitutional because it had a series of criteria that, under the Apfel decision, had been satisfied. Specifically, it was a severe retroactive liability on a limited class of parties that could not have anticipated the liability, and the extent of that liability is substantially disproportionate to the party's experience. As a result of that, he found that that theory of liability violated the Constitution on substantive due process grounds.
So you mentioned earlier that the Apfel decision was really a plurality. Does that mean that we have to look at our constitutional arguments differently as we try to construct them?
Well, I think both as appellate attorneys and trial attorneys, also college or law school professors, it's interesting because it's the application of a rule from a Supreme Court case which is not unanimous. And one has to pay great attention to the scope of the reasoning utilized in the opinions, how those opinions either fit together or don't fit together, and then how they would be applied as a rule of law for purposes of this decision and further decisions. I'm sure with regard to other similar cases, and in this case, should it go up on appeal, that will be the point of discussion as to whether or not a U.S. Supreme Court opinion like Apfel can be utilized in this type of way.
So you mentioned that the Judge Randa decision in Gibson essentially overrules the state Supreme Court decision in Mallet. Is there anyone in a case like this that, other than the plaintiff's lawyer, that comes to the defense of the state court rule?
We don't have the federal equivalent of a solicitor general that might take that role. So rather it will be the plaintiffs who will have the opportunity, should they decide to appeal it, or in other cases, similar cases, to argue that the way that Apfel was applied, the way that the Apfel opinions were considered and joined, whether or not that was correct or incorrect.
So I guess sometimes the decision of a court of last resort isn't the end of the story. Is that right?
I think that's true, and that's what makes it interesting. And one of the reasons why why I wrote the article was, here you have federal district courts and a federal appellate court, which in diversity are interpreting Wisconsin law, and as Wisconsin practitioners, judges, etc., we're often very focused on what do the Wisconsin trial, appellate, and Supreme Court say about our law. Well, there's this other whole system, of course, of federal courts, federal district, appellate, and U.S. Supreme Court, who are weighing in and interpreting Wisconsin law. And I think it's always important to keep that other court system in mind and note how their applications are important. In the article, I discussed Wisconsin fair dealership law, Wisconsin property law. In a past article, I discussed Wisconsin criminal law in the habeas corpus context. And these other federal court decisions are all very important to know and sometimes even apply, whether you're in Wisconsin state court or Wisconsin federal court.
Well, I didn't have to deal with the two different systems. In the article I wrote about 10 different state of Wisconsin Supreme Court decisions from this past term. I wrote about 5 civil cases and decisions in 5 criminal cases.
Was there one of those that to you stood out as having an impact from the Wisconsin Supreme Court?
Well, I think one that is particularly instructive and on a question on which we don't get a lot of instruction from the state Supreme Court involved the process of amending our state constitution. That was McConkey versus Van Hollen.
What was the holding of that case?
Well, the holding there was that the amendment as drafted, and this is the marriage amendment, I can read the language of it to you in a minute, met the single purpose requirement, and thus the court was not going to invalidate the amendment.
What did the amendment say?
Sure. It said it consisted of 2 sentences, which I think is part of what provoked the challenge. The first sentence reads, "Only a marriage between one man and one woman shall be valid or recognized as a marriage in this state." And then the second sentence was, "A legal status identical or substantially similar to that of marriage for unmarried individuals shall not be valid or recognized in this state." There were several sort of preliminary issues that the court disposed of first. One was standing, and in general, and this was a unanimous court speaking, the court is interested in granting standing on questions of this import, the validity of a ratified amendment. So standing was acknowledged, and then the next point that the court made was that not on the table was any discussion of the merits of the amendment. This was purely a procedural issue posed.
Did the decision then therefore have some type of impact in the future for people who are writing constitutional amendments?
I think that is the great benefit of it. The case affirmed prior Wisconsin Supreme Court precedent on how to analyze an amendment, and the test that this challenge hinged on was the general purpose test, that there is one general purpose to any proposed and adopted amendment. The challenger, I think, tried to suggest there were multiple purposes, but the Attorney General's response was that no, really the additional statement within the amendment is supportive, and to take to parse that further would really deprive the legislature of its discretion.
It sounds like the decision might have had some separation of powers implications. Is that true?
I think very much so. It was a Supreme Court recognition of one, sort of the will of the electorate in getting the amendment proposed, and then the legislative discretion over the period of several sessions in ratifying it as drafted.
What also sounded interesting about it was the interaction of the state Supreme Court with the electorate. Can you speak to that?
Well, I think in general the court's message was we want the people to be able to express themselves. And so we aren't going to unduly hem in some of the descriptive language that might be part of the amendment, but still furthering one single purpose.